Hi everyone, welcome to Impact Academy. So today let us continue with the polity questions. So last session we have seen till the 20th question. Let us continue from the 21st one. So why did the founding fathers of India prefer the British parliamentary system over the US presidential system? So when the Constituent Assembly was there and it was discussing about what kind of system we would have, so there were two options. One is the British parliamentary system, and the other is the U.S. presidential system. So in the British parliamentary system, you have the Prime Minister who is the executive head, and the President is only the nominal head, and you have a cabinet, what is a cabinet of ministers who will be advising the Prime Minister, and the Prime Minister's decision will be the cabinet's decision rather will be binding on the president. In the US presidential system, the president is different from the Senate. Okay, the congressmen, the senators, etc. They are responsible to the parliament, and the president is not directly responsible to the parliament. Okay, he is the what you can say individual. He works somewhat individually apart from the Senate. So if you look at the options, the parliamentary system was more familiar to Indians. So this statement is correct because by that time, starting from around 1700s or so, the British started interfering in the administration of the Indian territory. So we had so many acts and everything, and by 1857, the control was directly in the hands of the British Crown. So right from then, so by that time it had been already around 100 years or so, we were familiar with the parliamentary system. So that is one of the reason, and they wanted to avoid conflict between the legislature and the executive. So that is also true. So normally, if you look at the U.S. presidential system, there is always frequently conflict between what you say the House, the Speaker of the House, and the President. So recently, also you could see some years back, Donald Trump and Speaker Nancy Pelosi. Okay, so they had frequent conflicts. So there is in the presidential system, you can observe a certain type of conflict between the legislature and the executive. In India, they felt that it is better to avoid such a thing. So, in case of a parliamentary British parliamentary system, there is an overlap between the legislature and the executive. So, when you are talking about the legislature, I mean, this prime minister, cabinet ministers, everyone, they form part of the legislature. While making policies, enacting laws, they are part of the legislature. And the same people, when they run the government and when they what you say execute the policies also, it is the same people who are on the head of the executive. So because both are same, the chances of conflict will be very less. Next, if you see, they believe the British parliamentary system offered more stability than the US presidential system. Now if you look at the benefits of the British parliamentary system, it offers uh, he is saying it offers more stability than the US presidential system. So it does not offer more stability because if what you say there is no confidence in the government. Suppose anyone moves a no confidence motion, we frequently see, right? The government falls, the government collapses, and whenever there is no majority, whenever there is a coalition government, also yeah, immediately when some opposition plays a trick or some MLAs jump from one party to another, you often see that there is a loss of confidence in the government and the government collapses. So there is relatively low stability. But in the US presidential system, once the president is elected, is not is what you say not directly linked with the Senate or anything. So he works as the executive independently of the legislature. So in the US presidential system, there is more stability. Okay, once a president is elected, he has to be impeached. Otherwise, it's not like if there is no confidence, if the number of senators are what you say, just like how we see in our parliament, it doesn't happen in the US presidential system. So, in the British parliamentary system, the common point is it offers less stability, but it offers more responsibility. And in the US presidential system, it offers more stability but less responsibility. So that is a very standard statement. So we opted for more responsibility compared to stability. So 1 and 2 will be the option. Okay. So it's option B. Okay. That is 1 and 2 only. So if you look at the 22nd question. Which of the following recommendations of the Sardar Swaran Singh Committee were not adopted in Part 4A of the Constitution of India? So we already discussed this multiple times, right? In 1975, when there was emergency, and then in 1976 we had this 42nd Constitutional Amendment Act, and the government set up this Sardar Swaran Singh Committee, especially to make recommendations about fundamental duties. And immediately when you say fundamental duties, the first thing you have to remember is uh, where did we take the fundamental duties from? So the sources of the constitution is also very important. So look at this Russia. We have taken the fundamental duties and the ideal of justice in the preamble from Russia. Try to remember these two things: fundamental duties and the ideal of justice. Okay, usually liberty. Liberty will be French. Liberty, equality, fraternity, and the suspension of fundamental rights during emergency is Germany. Okay, all these are very important. Anyway, fundamental duties we have taken from the Russian constitution. And in the Swaran Singh committee recommendations, actually there were many recommendations. Not all the recommendations have been adopted. Most of the fundamental duties which we see now, they have been what you say adopted, but there are certain other what you say recommendations which have not been adopted. One of them is penalty for non-compliance of fundamental duties. So fundamental duties, they are just like what you say guidelines to the general population. Okay, general what you say moral obligations. That's all. There is no penalty for non-compliance of the fundamental duties. No law imposing penalty or punishment for the violation of fundamental duties shall be called into question in any court. So when the committee when the committee gave the recommendations, it gave this recommendation also, that one thing is there should be a penalty for non-compliance, and nobody should question that in court. But in India, whenever usually when you see this concept of it shall not be called into question in any court, such things will not be what you say accepted by the Supreme Court. So usually such things will be struck down, because judicial review. Okay, any law, any act, etc. Anything comes under the purview of the judicial review. It is one of the basic structure of the Constitution. So even though this has been proposed by the Swaran Singh committee, it was not accepted by the government. And also duty to pay taxes by the citizens. So this is also true. Remember these things. These three have been recommended by the Sardar Swaran Singh committee, but they were not accepted by the or implemented by the government. So answer is D. 1, 2, 3. So all three are right. Try to remember that. So, in the context of applicability in the Indian political system, consider the following elements of A.V. Dicey's concept of rule of law. Now, A.V. Dicey is a prominent, what is a jurist in the British government. Okay, and he propounded this concept of rule of law. So, according to this rule of law, what it means is absence of arbitrary power, which means that if you want to punish any person, you can only punish for a breach of law. So it shouldn't be the case where suppose tomorrow the prime minister or the minister will say, I don't like that person and I want to put him in jail. It is not possible. Okay, that is arbitrary power. So you can only punish someone if you had committed some mistake. Only if there is some breach of law or some crime he had committed. Okay, so that is absence of arbitrary power. And he's talking about rule of law. Okay, if you want rule of law to prevail, there should not be any arbitrary power, and also there should be equality before law. Now in India we have Article 14, right? Equality before law and equal protection of laws. So this is also one of the concept of rule of law of A.V. Dicey. And if you look at the third one, the primacy of the rights of the individual. Now, what it means that when you take the rights of the individuals, okay, whatever rights the individual have, you bring all of them together, and that forms the constitution. Okay, that is what Dicey is saying. So, this British jurist A.V. Dicey is saying that if you want rule of law to prevail, there should not be any absence of arbitrary power, and there should be equality before law, and the rights of the individual are given primacy. So they are given the highest what you say crimes. Now, which elements of A.V. Dicey's concept of rule of law are applicable in India? Okay, he's talking about in the Indian political system. So, so try to understand this. According to A.V. Dicey's concept of rule of law, all these are correct. All three are given by A.V. Dicey. But he is not asking whether these belong to A.V. Dicey. He is asking whether these belong to the whether these are applicable in the Indian political system. So if option one is available, right? In India, Indian political system, you cannot arbitrarily arrest someone unless they have committed a law. So this is there. Equality before law is there. Article 14, 15, 16, all those right to equality we have seen, right? So this is also applicable to the Indian system. But if you look at the primacy of the rights of the individual, okay, in Indian political system, the constitution itself is the source of the what you say individual rights. Okay, the constitution is the source of the individual rights, and the rights of the individual are not supreme. If you take, for example, even within the fundamental rights, Supreme Court had many times told that they are not absolute. There are certain restrictions, and the right to property has been removed because it is coming in the way of the welfare. In the First Amendment, what they've come with a lot of these land reforms. Okay, each person was having hundreds of acres of land, so they came up with the Land Ceiling Act, etc., where they said you cannot have more than 2 acre, 10 acre, etc. So many people went to court saying that it is against their right to property. So right to property was removed as a fundamental right, and it was made a legal right in Article 300A. So basically, we are not the primacy of the rights of the individual is not supreme in India. The constitution is supreme. Okay. So in Indian system, three is not applicable. So I would say only one and two only. So answer is C, one and two. So don't get confused. All these three are propounded by A.V. Dicey. But in Indian system, the primacy of the right of individual is not there. In our Indian system, the rights of the individual come from the constitution itself. Whatever the constitution provides, only that becomes our right. Whatever is the right of the individual, okay, I mean, whatever the individuals feel that it is their right, it is not accepted. So the primacy of the rights of the individual is not there in the Indian political system. Okay, try to understand the difference. Let us go to the next question. So in the federal government, all powers are vested in the national government. Okay, so if you look at federal government, the reason you say federal government means federal structure means what you have a center and then you have the states. So, India is also a quasi-federal government or a federal government with unitary tendencies, etc. And all powers are vested in the national government is not a very correct statement because if you look at law and order, it is a state subject. Okay, and if you look at what you say the state list, okay, concurrent list, union list, you can see that there is a differentiation. In the state list also there are 61 items, right? So, to say that all powers are vested in a national government is a wrong statement. There are significant powers to the federal states also. And second statement, in a unitary government, the regional governments derive their authority from the national government. Okay, so you can say that is true. Why? Because he's talking about a unitary government, not a federal government. So it is a unitary government. That means the union is very powerful, all powerful. The union government is the only government that is there, which is the case in actually many of the countries. Many of the smaller countries, there is only one government. You don't have states, state governments, etc. So regional governments at the local level derive their authority from the national government. So this is true. So I would say only B only. So it is B only. Two only. So in a unitary government, regional governments derive their authority from the national government. That is a right statement. Okay. So let us look at the last question for today. Consider the following statements with reference to the fundamental duties. So fundamental duties means first thing it has to come to your mind is part 4A. That is one thing. And Sardar Swaran Singh Committee 1976, 42nd Constitutional Amendment Act 1976. Okay, and initially 10 were there, then 11th one was added. So all these things you have to remember. So they can be used by the courts in determining the constitutional validity of the laws. Okay. Now, you can say it is true because fundamental duties, though it's not like legally enforceable or anything, they can be used, definitely used by the courts in determining the constitutional validity of the laws. Because sometimes you may make a law trying to give effect to a directive principle. Okay, but it may come in conflict with a fundamental right or fundamental duty. So in such a case, yeah, there will be some what is a confusion or ambiguity. Then the courts can use these fundamental duties or directive principles of state policy, etc., to determine if the law is constitutionally valid or not. So one is a reasonable statement, and Parliament cannot provide for a penalty in case of failure in fulfillment of any fundamental duty. Now, if you observe in the previous question, we have discussed that Sardar Swaran Singh Committee also mentioned about penalties. Okay, and the penalty for not doing the fundamental duty, and but that penalty should be what is say not questioned in the courts, etc. All those things we've seen. So, though the government of the time did not accept those three recommendations, the parliament does have the power. Okay, if the parliament so wishes, it can make for laws to what you say provide for some form of penalty or punishment, etc. If I mean, as of now, there is no such thing as if the fundamental duties are not fulfilled, there is no penalty as such. But the parliament has the what is the right to provide for penalty. So in this case, he is saying parliament cannot provide for penalty, which is not true. So he is asking which of the statements given above are incorrect. So two only is the incorrect statement. So answer would be B. Okay, the answer is B. Fine. So let us continue with the next five questions in the next class. Thank you.